Hello, I am Tutor Ricky's teaching partner. My name is Suzuki. I will be explaining the content of this video to you. This video explores business and company law, specifically examining a part of a past exam question from the HKICPA QP Module 10, Business and Company Law. It delves into sections of common law related to derivative action. Let's begin discussing the topic now. Question: Friendship Company Limited, FCL, is a private company incorporated in Hong Kong. It was formed by three good friends, Amy, Betty, and Catherine. FCL adopted the Model Articles for Private Companies Limited by Shares as its articles. It was agreed that Betty and Catherine would work full-time and manage the daily operations of FCL, while Amy would only contribute capital to FCL. Betty and Catherine are the two directors of FCL, and each owns 2,000 issued shares in FCL. Amy only owns 1,000 issued shares in FCL. Recently, Amy discovered that FCL had entered into a transaction in which Betty's and Catherine's families might have interests. As a result, Amy, Betty, and Catherine had been in a serious dispute. Amy, as a minority shareholder of FCL, is concerned that the above transaction had not been entered into for the benefit of FCL and would like to bring an action against Betty and Catherine on behalf of FCL in order to stop the above transaction. However, Amy has been advised that she is not allowed to sue on behalf of FCL and that only in very exceptional circumstances may she take action for FCL under company law. Required. In relation to company law, analyse what are the exceptional circumstances under the common law in which Amy can take action for FCL against Betty and Catherine, and what action is available to her as a minority shareholder under common law. In this question, the requirement pertains to common law related to derivative actions. The answer should include relevant cases that relate to the question. Let's break down the situation for a clearer understanding. Background 1. Friendship Company Limited, FCL, is a private company in Hong Kong. 2. Formed by three friends, Amy, Betty, and Catherine. Third, FCL adopted the Model Articles for Private Companies Limited by Shares. 4. Betty and Catherine manage daily operations and each owns 2,000 shares. 5. Amy contributed capital and owns 1,000 shares. Key facts 1. Amy discovered a transaction involving Betty's and Catherine's families. 2. This transaction led to a serious dispute among the friends. 3. Amy is concerned the transaction was not in FCL's best interest. Actions 1. Amy, as a minority shareholder, wants to take legal action against Betty and Catherine on behalf of FCL. 2. She has been advised that she can only do so under very exceptional circumstances according to company law. In summary, FCL, a private Hong Kong company, faces a dispute as minority shareholder. Amy discovers a potentially self-interested transaction by directors Betty and Catherine. Amy seeks legal action on behalf of FCL, but can only proceed under exceptional circumstances. After identifying and analysing the question and requirement, we now start the answer to the question. Answer. The question required candidates to discuss the derivative action under common law. The basic company law rule is that a shareholder has no right to bring an action for the company. There are also some exceptions to the basic company law rule. The rule is based on a case known as Foss v Harbottle 1843. In Foss v Harbottle 1843, two minority shareholders brought an action against 5 directors, alleging that they had misapplied the company's property and given mortgages improperly over the company's property. The two minority shareholders asked for a declaration from the court that the directors were responsible for the loss of the company, and also asked the court to appointed by majority shareholders in the general meeting, and 2 minority shareholders could not, as 2 individuals, bring this claim. Only the company itself could bring it. The result of the case is that either the shareholders with majority vote in a general meeting can bring a case in the name of the company, or the board of directors can bring it, but not 1 or 2 shareholders alone. The 2 important principles referring to the case are: the majority rule, and the proper plaintiff rule. In Foss v. Harbottle, 1843, it also set out the 4 exceptions where the minority shareholders may bring a derivative action on behalf of the company. 1. Fraud on a minority. Where the management or majority shareholders improper exercise of voting power by the majority of members of a company to defraud a minority, the individual shareholder may bring an action for the company. 2. Ultra vires and illegality. Where the act of the company is ultra vires or illegal by statute, the individual shareholder may bring an action for the company. 3. Special majorities. Where the constitution of the company requires, say, a special resolution, as necessary to do some act but the company only did it by ordinary resolution, the individual shareholder can litigate it. 4th. Personal rights. Where the Articles of Association give the shareholders rights which they can enforce against the company, the rights cannot be taken away by ordinary resolution. In this case, as Betty and Catherine are the directors of Friendship Company Limited FCL, and they have interests in the FCL's transaction without proper approval at a general meeting of the shareholders, Amy may rely on the ground of fraud on a minority and bring a derivative action against them. For common law derivative action, no particular step is required. Amy, as a minority shareholder, may bring an action in the name of FCL and prove the exceptions under the rule of Foss v. Harbottle, 1843. Amy needs to finance the proceedings first until she is able to prove her case in court of law, where an order of costs may be made in her favour. The remedies are provided to FCL and not to Amy. Here is a summary of the key points related to derivative action under company law for the answer. The question discusses derivative action under common law, based on the case Foss v. Harbottle 1843. It outlines that shareholders generally cannot sue on behalf of the company, with exceptions like fraud on a minority, ultra vires acts, special majorities, and personal rights. Amy, a minority shareholder in FCL, can bring a derivative action against directors Betty and Catherine for a transaction involving their families, citing fraud on a minority. The video has now ended. Thank you all for watching. Goodbye.